Hello and welcome to another presentation. In this short presentation I'm going to discuss trusts as well as asset protection within the trust. I have had issues, as many of you may know, with the local municipality who break the law, and I'm sure that many of you are in the same position. Now this applies to trusts whether you're in Canada or the UK or United States or wherever you may be. Many people seem to think that if you put your property into a trust, that's going to save you from some sort of litigation by the municipality. That, my friends, is incorrect. I've done extensive research on this topic, and let's just say that you put your property into a trust, or you set up in the UK through Companies House and do a deed poll transfer. In any event, it's not going to solve the problem. And the reason is that if the municipality or the council put have a judgment against that piece of property because they think they own it, then let's say it's in a trust. At the end of the day, you are the beneficiary to the trust and somebody is the trustee. So at the end of the day, if the trustee comes along and shows you a problem, in other words, there's some sort of a lien or judgment against your property or against the trust property, at the end of the day somebody is responsible. So the trustee then would have to be responsible, and he may come to the beneficiary and tell him about it or her about it, and at the end of the day the trustee still has to solve the problem. So at the end of the day, technically you are still faced with the problem. So putting your property in a trust in the form of asset protection against the judgment won't do you any good, and it won't protect you. What the trust will do, if it's set up properly, is the trust will allow you to give your property or transfer your property to a secondary beneficiary. So if you had a family, a husband, a wife, and a couple of kids, and in the event of the husband and wife passing away, instead of the property going through probate, which is basically the lawyers and the courts get a hold of it, the property would simply revert to the secondary beneficiaries, which would be your two children, or 3 or 4, or however many you have. That's where a trust would help you. Now a trust has to be set up properly in order to do that, and the other thing that would happen if you want to use it for asset protection is if the trust owned property, let's just say it was a vehicle, a car, truck, whatever, and it was involved in an accident, then the party that was in the accident would attempt to sue the owner. Now if the owner is a trust, and the only thing that the trust has as equitable property is a vehicle, i.e. the one you were driving prior to the accident, then they may be able to seize the assets of whoever owns the vehicle. And since that's the trust, and the only thing the trust owns is the vehicle, then the only thing the injured party could go after would be that vehicle. Whereas if you are a conventional setup, a normal way people do it, if you are in that accident and you own a property and a vehicle and maybe a boat, maybe have some investments, then the person involved in the accident with you could therefore go after the assets of the owner, and in this case it's a conventional situation, which would include the house, your vehicle, a cottage, a boat, and any potential investments to settle the debt. So we can now see from this scenario that it would be better off to put your vehicle and your house into a trust. Now that's quite lengthy, and I'm not going to go into the explanation of the various trusts and or the possibilities therein. One thing I can tell you for sure is you don't want to be the trustee and the beneficiary, because the trustee is responsible to settle the debt or the obligation of the trust, and if you're the beneficiary and the trustee, the court can order the trustee to settle the debt, and therefore you would have a problem because there's a conflict of interest given the fact that you're both beneficiary and the trustee. So this is not allowed under trust law. The other thing that you want to keep in mind is that a trust, if it doesn't have any assets, is probably not valid, so we have to set that up differently. And on top of that, if you have a trust, and there's three parties to a trust. There's the grantor settlor, which is the person that sets it up normally. Then there's the trustee who administers the trust, and then there's the beneficiary who benefits from the trust. Now, you can play any two of the three parties, but if you're not familiar with administering a trust, then you might want to get somebody that knows what they're doing. And the same thing with setting up the trust. You would want to get somebody that knows what they're doing, and then you would become the beneficiary, and then your spouse or children would be secondary beneficiaries in the event of your passing. The other thing that you would want to do if it's a trust for asset protection, so you can leave something for your family, is that trust would not perform any function, i.e. it would not make a product, sell a product, or provide any service. Therefore, there is a limited liability in that setup, because why would that trust ever cause anyone any sort of harm or damage? These are just a few simple facts to deal with when you are dealing with the trust. I hope you found this information useful, and as time and resources permit, or I get enough questions on a certain topic, I will post a short follow-up video to answer any specific questions if I have enough of them. Thank you for your time. Have a good day.